House 559, Probation Before Judgment, Probation Agreements, Probation Not Deportation. Favorable report is amended, adopted.
Madam Speaker.
Recognizing the maker of the motion.
Thank you, Madam Speaker. I just had a few more questions because I did read the bill in depth and do some research. If the floor leader could yield before I offer the amendment.
Floor leader.
Thank you, Madam Speaker.
Thank you, and happy St. Patty's Day. Two main questions here. This bill, from what I gather, seeks to create a special probationary status. Is that accurate?
No, that's not accurate. This bill creates a new variation in order to enter probation before judgment.
Great, great, great. So can a regular citizen opt in? Because from what I read in the bill, it's specifically aimed at folks that have non-legal status. So can an everyday citizen opt into this plea?
Everyone, any Marylander can opt in to do this form of a probation before judgment statute. And as I mentioned when the bill was first up, for those that have federal employment as well, it could be a favorable option for them to use for misdemeanor offenses.
So this will create a new sort of overarching status for probationary before judgment?
Yes, Delegate. Anything that we pass in criminal law here in the state of Maryland applies to all Marylanders.
Great, great. And then the second question I have is that does the person that's being accused of the crime, do they have to disclose to the state's attorney? Because it talks about conversations that the state's attorney would have with the person and elect and say affirmatively, hey, I just want to let you know that I'm in a legal immigrant status.
So I think that every time you have a client and you're litigating any case, there's many facts that you, as a defense attorney and a prosecutor, talk about when they're entering a plea agreement, like prior acts, criminal history, things they've done. Maybe they're taking classes, maybe it's like an alcohol offense. So there are many factors that you give a state's attorney when you're getting into a plea agreement on to get to that plea. The bill does not in any way codify information that you have to let the state's attorney know, but any defense attorney and many that are on this floor, you would be giving information that's favorable in your discussion so you both can get to a place on a plea agreement.
Yeah, so my concern there, and I'll try to phrase this in the shape of a question, is that the reason that any defendant is going to opt for probationary status, obviously you don't want to get convicted, you want to try to make yourself right, but in doing so, one of the compelling facts is, oh, by the way, I'm an illegal citizen. So one of the reasons that I would like to get this probationary status is because if I do get convicted, that's going to put me, obviously I'll be convicted of the crime, but also now I'm on the radar of the federal. So
right,
why would someone be, we're compelling them to implicate themselves in favor of trying to get the probationary status?
Thank you, Delegate. Well, when it comes to the information for someone who is either undocumented or has a legal status in Maryland, and they're communicating with the state's attorney in order to get a plea agreement, you would be having that conversation attorney to attorney. And like I said, there are many individuals that would seek this type of a probation before judgment. Like I said, U.S. citizens who have a federal job. Many people are here, a visiting professor or someone here on a visa or a green card, because that could affect them later on, and someone undocumented. Anyone could enter into this plea agreement. I also would add that it doesn't take away from our current probation before judgment statute, because let's say you were found guilty by a judge and then you wanted to do a motion for reconsideration about your sentencing. You would still need the original PBJ statute because there was a guilty finding. In addition to that, any probation before judgment that is given at the courtesy of the judge in question, right? So when you enter a plea agreement, there's a sense that the judge is going to actually give that to you. It's not something that's guaranteed. It's something that's authorized through the judge overseeing the case.
Yeah, that's very helpful, thank you. And I do support the spirit of trying to make better, get on probation, get your life straightened out, and not get convicted in the future. However, I do have an amendment at the desk, but thank you for answering those questions. The amendment moves so much be considered the reading of the amendment.
So ordered.
The amendment number is 373528-1.
Amendment number 1.
Great. And based on the testimony there, I do appreciate the merits of the bill. However, I do have some concerns, and I did email this, this amendment to the floor leader, which you received. So I'll just outline what this amendment does. It basically says that, yes, we want probation, we want folks to get straight. However, there are a couple of crimes that we don't want this to be offered for. And you might make the argument, well, you know, you're never going to be awarded probation for the crimes that I'm about to list. But as we've seen many times, if it can happen in the court system, sometimes it does. So this creates 5 categories of crimes that you couldn't use this for. The first one is a crime of violence. Second is rape in the first degree. Third is rape in the second degree. Fourth is sexual offense in the third degree. And then fifth is possession of CDS with intent to distribute or dispense. Very straightforward amendment. And as I said earlier, yeah, these are crimes that you're probably not going to get probation for. However, there's nothing wrong with putting that in statute. And with that, I'd like to press the amendment. Thank you, Madam Speaker.
Madam Speaker.
Floor leader.
Yes, Madam Speaker, I would like the body to resist this amendment. And I ask you to resist this. In Criminal Procedure 6-220 already outlines what a probation before judgment can be used for. And the crimes that you listed, many of them are prohibited. You cannot, right now, in 6-220 Criminal Procedure article, offer a probation before judgment for any of those, as well for the ones that you listed for CDS and crimes of violence on second offenses. The probation before judgment that is in the legislation that is offered here today on the floor has all the same guardrails and conditions as our regular probation before judgment statute. And I'd ask the delegate to refer to 6-220 in the Criminal Procedure Code, and I would ask you to resist this amendment. Thank you, Madam Speaker.
Gentleman from Anne Arundel.
Thank you, Madam Speaker. The U.S. Constitution's 14th Amendment gives the states the inherent police powers to protect public health and safety. And I take the good delegate at her words, but once again, it concerns me that we pass these things and somehow it gets misinterpreted when it gets to the next level. And some of these crimes that the good delegate from Cecil County mentioned are crimes that people don't ever rehab from. First-degree rape, second-degree rape, they're heinous. They're life-changing. They will destroy somebody's life. I'm not a lawyer, but once again, a common sense amendment like this that just serves to protect our citizens that we've all raised our hands and took an oath to protect will do nothing negative, but can only do positive if we pass it. Thank you, Madam Speaker.
On the amendment, all in favor signify by saying aye. Aye. Opposed?
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
Has everyone recorded their vote? Clerk will take the call. The amendment fails. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading.
Move so much to be considered the reading of the